Hey, thank you for joining us today. We have two people who are on top of the game in terms of independent contractors, particularly as it comes to trucking. Mike Traxler, leader of our transportation division, and Steve Fleury. Guys, let's kick it off by the most recent, as I understand, permutations from the Department of Labor, the standards that are proposed by them. What do we got and where's it going?
So, Doug, I'm happy to address this. The Department of Labor earlier this year had come out with a new rule that establishes a 6-factor test for determining when workers may be classified as independent contractors. Now, this is really a reversion to a prior pre-Trump administration rule. In recent years, the U.S. Department of Labor had effectively focused on 2 components of that former 6-part test. And so what the Department of Labor said is that historically, we have used this 6-part test and we're going to go back to it. And so that rule change by the Department of Labor became effective March 11th of this year. And in practice, from a Department of Labor federal standpoint, it likely means that we have more individuals who are going to be classified now as independent contractors as opposed to employees. The new rule is more in favor of establishing the employment relationship between employee and the business. And so, what are these 6 factors? And the 6 factors that the court and the agency is going to look at, the agencies, at least the U.S. Department of Labor is going to look at, are number 1, the opportunity for profit or loss, depending upon a worker's managerial skill. And so, the agency and the court is going to look at things such as whether the worker accepts or declines jobs or chooses the order and time of which they pick up, a load or are obligated to drop off a load. Whether the worker engages in marketing, advertising, or other efforts to expand the business or secure more work for him or herself. Whether the worker makes a decision to hire others or to purchase materials or equipment, his or herself. So that's what we're looking at in terms of opportunity for profit or loss, depending upon managerial skill. Number 2 is the investments by the worker and the potential employer. Previously, up until this new rule change, it was a strict application of, the employer obviously is the prospective employer is obviously going to contribute more than any independent contractor, right? There's different economies of scale. And what the new rule change says is that we're going to look at the relative application of what the contractors are investing versus what the prospective employer is investing. And so that rule change itself makes it more likely that an independent contractor relationship exists. Number 3 is the degree of permanence of the work relationship. Generally speaking, if the working relationship is definite in duration, it's for a set period of time. If it's non-exclusive, those are things that are going to support the independent contractor relationship. And these are things that really should be addressed, and we'll talk about this in a bit, in your independent contractor agreements with your workers. Number 4 is the nature and degree of control. Does the employer, prospective employer, or does the independent contractor have control over scheduling, supervision, setting of prices of goods or services, and the ability to work for others? Number 5 is the extent to which the work being performed is an integral part of the potential employer's business. Stated differently, if that independent contractor, if that prospective employee were to leave his or her position, will that have a lasting effect on the company? And number 6 is skill and initiative. Whether the worker utilizes specialized skills to perform the work, and whether those skills contribute to a business-like initiative. For purposes of obviously requiring a CDL and various, health examinations and so forth. Generally speaking, that is going to be viewed as requiring some type of specialized skill. So that is helpful in terms of establishing the independent contractor relationship. So these 6 factors that I just spoke of under the new rule are not exhaustive. The agency and courts can look at other factors if they're relevant. The agency has also said that not any one of these factors that I just discussed are dispositive. They're to be given equal weight as much as possible. And so that's what we have in effect right now from the federal U.S. Department of Labor perspective. Again, it went into effect on March 11th. And as we go on here, we're going to talk about some other tests that are also going to be applicable based on other federal agencies and from the state level as well.
Mike, for a trucking perspective, Department of Labor rules that Steve had just addressed, what are your thoughts?
This has been a hot topic for the industry for a few years now. You'll recall AB5 out of California. New Jersey proposed the ABC test, and over the last couple of years, Department of Labor has gone back and forth with change in administration as to what test it is going to use. So there's been a lot of confusion in the industry as to what test applies to any particular motor carrier. And recently, this has been even more of a hot topic. It's been in Transport Topics. ATA has put out a lot of press on this, but if you've seen it, there's video of Representative Kiley, a Republican out of California, who recently at a House committee meeting was grilling the acting Secretary of Labor on these issues. In particular, he was putting forth the ATA's position that it is advancing through its Women in Motion group, essentially highlighting independent contractors in the trucking industry and how these changes in the federal law are going to greatly impact independent contractor truck drivers, but disparately impact female truck drivers who oftentimes are, the sole breadwinner in their homes and rely upon this income to put food on the table for their families. And it was interesting during the questioning of the acting secretary, Representative Kiley asked her if she even knew how many independent contractor truck drivers are out there. And this person who is responsible for putting these policies in place couldn't even answer that question. So I think that speaks to how much thought is going in to the process, which obviously adds to the frustration. So earlier this year, Steve put out a great article when this change in the analysis was being proposed by the Department of Labor. And we pushed that out to our listserv of trucking clients. And the feedback we got, the question we got most often was, how does this apply in relation to the other federal tests from other federal agencies? And how does it apply in relation to the tests that the various states apply? So that speaks to the confusion around this new federal test in relation to all the other tests that are out there. So, Steve, I know you had some thoughts on how these various tests apply to one another, whether others supersede others.
Yeah, Mike. So, as you pointed out, there are several tests out there, and the application of the test really comes down to what agency, whether a federal or state agency, and again, it varies from state to state, what agency is pursuing an audit, an investigation, an alleged violation of its rules and regulations against, a particular trucking company. And so, in your unemployment compensation situation, there's going to be a test that applies. In your workers' compensation situation, if that's at issue, there's going to be a separate test that applies. If you're being audited by the Pennsylvania Department of Labor, there is a separate test that applies. Now, we're talking about all these separate tests that are in existence out there. And so it raises the question as to what do I do as a trucking company? How do I respond to this? How do I try to insulate my business and protect from liability as much as possible? And the answer to that, while not necessarily easy, is that there are some common threads we see throughout these tests. And it really does come down to, if I could boil it down, to an economic reality type test. So in other words, is the independent contractor, does the evidence or prospective employee, of course it's an issue at that point, but does that individual do enough as a matter of practice, as a matter of economic reality, to establish that he or she is effectively in business for him or herself? Or the converse of that is, are they reliant upon the trucking company that is providing the work to him or her for their livelihood? And if they're reliant upon that trucking company that they are performing services for, that is highly indicative of an employer-employee relationship. The company wants to structure things as much as possible, both from a written agreement perspective, an independent contractor agreement, and in practice, to give that worker the opportunity to have some independence from the company. Whether that's independence from merely having to accept schedules from the company, whether that individual can go and work for another trucking company at the same time he or she is performing services for your company, whether they own the equipment, particularly the cab. These are all things that if the worker takes responsibility for, if the worker has the responsibility for in your working relationship, these are all things that support the worker being in business for him or herself and not for the company. So these are some of the critical things that you need to pay attention to as a business, to really try to cover yourself as much as possible from all of these tests that are out there and could be used in any given situation.
I like to boil it down, the economic reality factors, to what I like to call the skin in the game test. Does the independent contractor have skin in the game? When our clients come to us and ask, what can we do in this situation? One of the first questions I ask is, do your independent contractors have their own business set up? Are they an LLC? Are they a corp? If not, why not? Because it's a relatively easy process to go through. There's a lot of benefits to the individual who owns that particular business entity, tax-wise and otherwise. liability protections, that they should absolutely have it in place. But that gives the independent contractor skin in the game. We've heard a lot about, in the context of California's AB5, the business-to-business exemption. Look, the individual who owns a business are two separate and distinct entities for tax purposes, right? So when you are entering into these independent contractor agreements with another business, the owner of that business is separate from the LLC that's running, this truck driving company. So one of the ways to get around, or at least comply with a number of these tests, again, you mentioned the common threads, all of them seem to have this common thread that if there are two separate businesses entering into a contract, that's going to be one of the biggest factors that's looked at in any of these tests. So absolutely, when you're looking to enter into these relationships, make sure it's with another business. If your drivers are worried about or concerned about, starting their own LLC, they should go out and talk to an attorney of their own choosing and learn about the benefits of doing that if they truly want to be an independent contractor. The equipment ownership piece of it is another big factor in the totality of the circumstances analysis that is in most of these tests. AB5 is not one that considers totality of the circumstances. New Jersey's ABC test is unyielding. It doesn't, if you don't meet any of the elements, you'll be considered to be an employer in New Jersey. But we're talking about in situations where they are looking at the totality of the circumstances. Ownership of equipment is very important. And if your independent contractor owns the equipment, that's easy. You're going to do well in the analysis if they also have their own business entity set up. But a few years ago, lease purchase arrangements were very popular with trucking companies, where the trucking company had an asset, power unit, and they decide, okay, we're going to lease it to this owner operator who's coming in, and we're going to make it look like they own their own equipment, but they're not allowed to use this piece of equipment to haul loads for any other motor carrier. And if the relationship ends, then they might get some equity out of, this lease purchase arrangement, or they may not. But at the end of the day, the titled owner of that piece of equipment was still the motor carrier. And in the audits that we have been involved in where it was a lease purchase arrangement, the auditors easily saw through that and determined that, okay, the owner operator, the independent contractor doesn't actually own this equipment. It's being supplied by the company. And they considered that a strike against the company in the misclassification analysis. So for any company out there that's still operating under these lease purchase arrangements, there are alternatives, but traditionally to have the motor carrier operation leasing a piece of equipment that it owns to an owner operator, you're typically going to fail that element of any of these tests. So looking at ownership and ownership of the independent contractor's equipment and the separate entity for the business-to-business exemptions are two of the biggest factors to be considered in this analysis. And then you prepare an independent contractor agreement that's specific to the circumstances of your company. We see a lot of clients come in and they give us their independent contractor agreement that they've been using. And we always ask, where did you get this from? And more often than not, it's, well, my friend has a trucking company and we use theirs. Or the independent contractor had one from their prior arrangement and we used theirs. Or our corporate attorney who's been doing work since, the company started in the 1950s prepared it for us. You should be hiring an attorney who has specific experience representing motor carriers, trucking companies, to prepare these agreements. There are a lot of things that can be considered, and you should just not be using a form off the shelf or something you find on the internet. And it should be tailored to match specifically with your particular operation, because the auditors will look at the agreement, but they're also going to dig deeper into your operation to make sure that, okay, the agreement says you're not controlling whether or not they have to accept loads. They're going to talk to the independent contractor to see if that's actually the case. They're going to look at the titles to the vehicles to find out who owns the vehicles. So they will dig deeper. So these agreements need to be tailored specifically to what the operation is actually doing in practice.
We kind of skipped over a part, the benefits of the independent contractors. What are the benefits to both the independent contractor and the trucking companies? I mean, they're really the ultimate entrepreneurs, taking the risk on themselves and profit and loss.
Right. Steve, this is more your area than mine. You deal with this on a daily basis as to what the benefits are for companies to work with independent contractors as opposed to employees.
Yeah, so there's a number of benefits, and it's no surprise that companies try to go the independent contractor route, where it's possible, because there are a lot of benefits, and among them are there's no obligation to pay income, Social Security, or Medicare taxes. There's no obligation to comply with the Fair Labor Standards Act at the federal level. Or any really state wage and hour laws. This includes minimum wage and overtime requirements. There's no obligation to provide any benefits, such as health care, paid time off, or other common benefits. There's no insurance obligations from a workers' compensation perspective or an unemployment compensation perspective. And there's no obligation under many state and local employment laws, including health and safety laws and anti-discrimination laws. So by classifying your workers as independent contractors, there's a lot of benefits. And, we have seen across the economy as a whole in recent years, particularly, with sort of the dawn of Uber and Lyft and those relationships, between drivers and those companies and others, but there's been an explosion in recent years of folks being classified as independent contractors, and it provides a lot of benefits for the independent contractor as well. We shouldn't lose sight of that. It gives them a much greater flexibility than they would otherwise have as an employee. As we've been talking here today, we've talked about how, certain things supporting the independent contractor relationship, such as being able to determine effectively your own schedules, to work for other companies at the same time you're working for another company, to be in the business for yourself, to have that opportunity for profit and loss. These are things that benefit the independent contractor. So I think, on the whole, particularly folks at the agencies, federal and state, and certain politicians, that we listen to today, they focus primarily on the benefit to the prospective employer by classifying their workers as independent contractors, and make that out to be a bad thing. They're taking advantage of these independent contractors. And they ignore the flip side of that, which is that there are advantages for the independent contractors. And I think that's an important point not to lose sight of. And so, Mike, I don't know if you have any thoughts on that.
No, you mentioned the flexibility and the ability to control your own schedule. In the materials that ATA's Women in Motion group put together, that was one of the biggest themes in the feedback that they received from particularly the female truck drivers, was look, I want the ability to be home when I need to be home. I'm driving across the country back and forth. I want to be there for big events for my children. And being an independent contractor gives me the ability to do that. If I were an employee driver for a company, I would have no control over those things. So I think that's a big thing that has not been considered in any of these tests. And there's no one factor that really speaks to what the independent contractor wants. That's kind of lost in this whole analysis outside of what's in the independent contractor agreement. Did you, in your analysis, do you actually ask the independent contractor what they want, what they consider themselves to be? And that's not in any of these tests, unfortunately. And I think that speaks to other bureaucratic issues that we'll leave aside or for a topic offline. But, at the end of the day, the revenue from these programs are designed to, fill budgets for any government. So I think that needs to be considered. But the biggest point in what you said, Steve, as far as the benefits to the independent contractors is the control that they have over their own destiny and over their own schedule. So on the company side, you have to allow those things. You cannot penalize independent contractors if they, refuse a load, or if they say, well, that doesn't fit with my schedule. If you somehow penalize them for that, that's going to count against the company in the analysis.
How about guys, I know trucking companies walk the line in terms of certain requirements for drivers, be it in-cab cameras or otherwise for independent contractors. Where does that play into company requirements for independent contractors for certain technology or other things like that? Again, is there a line there, or again, are we talking shades of gray?
Definitely shades of gray, I think. And we typically, discuss that particular issue in the context of safety and insurance. Insurance being one of the issues that is often considered in these independent contractor tests, who's providing the insurance. We all know that federal regulations require that the motor carrier provide the public liability insurance. And under these tests, many of them, if the company's providing insurance, that's one of the factors considered against the company in the analysis. So with cameras and other safety features, it's something that's often driven by the insurance carrier. There's discounts involved. And we all know from our experience that having cameras in trucks actually helps to lower the amount of claims. And when there is a claim, they're helpful in a number of respects. So, ultimately, if an independent contractor, stands their ground and they don't want it, you'll have to give that some consideration. And maybe if the company has a policy of requiring them, it's not going to be a good fit for that independent contractor. But again, it's a safety issue as well. So I think that's easily explained in an audit if you require those kind of safety features, that it's not going to be, the deal breaker to say, okay, it's employee-employer relationship versus independent contractor.
And many drivers now are requesting themselves. The recent tanker accident up in Connecticut, absolved or exonerated in that, even though we're getting noise outside the submarine here. They got a video that a Camaro cut off the tanker driver and caused the entire accident up there.
Right.
Guys, we've talked a lot about the challenges and the various tests, et cetera. Best practices. What do you think?
Best practices from my perspective, and Mike touched upon this earlier, as did I, is first and foremost, you have to have that independent contractor agreement with your workers. And that agreement, as has been pointed out, should not just be a standard form agreement that you get off the internet or, from perhaps an attorney who's not familiar with the trucking industry. There are things that should be in that agreement. that give it greater force and effect than your standard sort of template agreement that you might find otherwise. Now, I also want to make the point that having that agreement is not a it's not a get out of jail free card, right? That just by having that agreement alone, with nothing else, does not mean that you are insulated against liability under these tests. I wish we could tell you that, but we can't. But the independent contractor agreement is an extremely important first step. It's a base level of insulating yourself that we can provide, and that you as a business should have. And so that's certainly step number one. Step number two is making sure that you have policies and procedures in effect that you follow. First of all, that it accurately reflects what you as a business do by way of your workers on a daily basis. That's one of the big things. You do not want written documents that really just do not reflect accurately, or in a worst case scenario, entirely contradict your practices as a business. So you want to make sure that your policies, your procedures, your independent contractor agreement are aligned with what you do as a business and your relationship with those workers. Does it accurately reflect those? And in terms of what needs to go into those things, it's a lot of the things that we've talked about here today. Assuming it accurately reflects your business practices. Is the truck driver able to decline a load without penalty? That if that's the case, that should be written down in a policy. That's something that we can absolutely point to in a defense of a motor carrier, in many instances. So let's get some of those things that support the independent contractor relationship down in writing, as many of them as we can that, again, accurately reflects your business practices. These are all, excellent first steps to helping to ensure that you as a business are not going to be held liable in these instances.
We've covered the business-to-business best practice already. The ownership of the equipment, the independent contractor should, own that equipment or be leasing it from an entity that's not the motor carrier. Whatever it is, business cards, a page on Facebook Marketplace, the independent contractor should be doing some type of marketing. Even if they're not handing out the business cards, on a regular basis, have some business cards with the business name printed on it. Ideally, and I know this is difficult with, the desire for exclusivity for the independent contractor to drive only for a particular motor carrier, but ideally, the independent contractor should be taking on some loads periodically for another trucking company. So their independent, their economic reality is not tied exclusively to one motor carrier. And, I often tell my clients, pick a model, go with one or the other, employee drivers or independent contractor drivers, not both. That's going to blur the lines for a number of reasons. It's going to blur the lines on compensation. If you have both employee and independent contractor drivers, there need to be vastly different compensation models for those two classifications. And even if you're just an independent contractor model, don't pay on a basis that would be typical for an employer-employee relationship. And in the context of truck drivers, that would be hourly or by the mile. If you're paying an independent contractor hourly or by the mile, that's kind of falling into that employer employee column. Some do's and don'ts that go along with these, these best practices that we're recommending. don't control the manner in which they're performing their services. Steve touched upon this, but we typically work into our IC agreements. Customers have requirements for deliveries to be made in a certain way, and by accepting a load, the independent contractor is agreeing to abide by those customer policies. So you make them more about the customer's policies. You don't want to, impose company policies on an independent contractor. Along the same lines, you should never be giving an independent contractor, a driver handbook or a driver manual or an employee handbook or anything like that. They're not bound by your policies, so you should not be giving them your policies if you have them. Similar to that, if you have employee benefits, health, dental, vision, et cetera, short-term disability that you offer to your employees, do not offer that to your independent contractors. On the liability insurance issue, as a motor carrier, you're required to have the public liability insurance, but your independent contractor can have bobtail insurance. They can have occupational accident insurance. They can have any other, manner of insurance, general liability insurance to cover their business. They should have those things. That legitimizes the fact that they are operating a separate and distinct business. Be careful with, just benign things that you might get in a form agreement, form independent contractor agreement, like confidentiality provisions and representations and warranties and, non-competes, being an issue now. You can't put in a non-compete with an independent contractor because that's contrary to what an independent contractor relationship is. So those are some of the more important do's and don'ts to protect your interest, when it comes to these various tests.
Great overview, guys. Final thoughts, Steve?
Doug, it's an increasingly tough world out there for trucking companies and others in terms of, as we've talked about, sort of the different tests, the changes in tests that constantly seem to constantly be coming out. And so, I think as a final thought, it's a recognition that legal counsel is particularly needed in today's day and age, a shameless self-plug for ourselves. But the trucking companies want to keep on top of things as much as they can. These changes in rules are coming out seemingly, a couple times a year. As Mike pointed out, we put out an article earlier this year concerning the independent contractor rule changes from the Department of Labor perspective. So, keep an eye out for these alerts. They have an effect on your business, and there's oftentimes things that can be done proactively to again minimize your risk of liability. Mike?
Along the same lines, don't wait until you get the knock on the door, the letter from a government agency. Get out ahead of it. There are some relatively simple things that you can do to avoid being misclassified as an employer. So be proactive about it.
Keep up to date on saxonstump.com. You guys are posting updates as things change as they come along. You can also sign up for the newsletters on there. We'll bring you up to date on any new changes on it. Steve, Mike, thank you very much. And hey, thank you for joining us today.
Thank you.
Pleasure.